Hey, Brian Parker here with the third in a series. We did the assignment video. That was number 2. I just did that. We did number 1. By the way, these are all based on the fact that we've got to create a request to produce for you, and that'll be attached to the this video or the other videos on killdebt.com. And the first video, of course, was on bill of sales. They're all joined together if you hadn't figured it out, and it'll all close in a great loop today. Both the bill of sale and the assignment and today the affidavit are all joined at the hip because each one plays a role in the other's lifespan. Generally though, today is, from an evidence viewpoint, the most important part, even though I think I had the most fun with the forward flow agreement in the bill of sale, because if you ask for the forward flow agreement, you're going to win that case. They're not going to give that to you and going to do everything to stop you within reasons. The judge isn't going to let them just bully you the whole time, but you will get that case settled if you have a reasonable, honest request. And as I said in the bill of sale / forward flow agreement, I think that was 5 days ago video. Check that out. Here's put it up. Okay, and then next to it, let's put the last video I just did on assignments and go to them to slay this dragon, to ask for that forward flow agreement. You're allowed, it's relevant, it's evidentially relevant, because their bill of sale says according or pursuant to the terms and conditions of a forward flow agreement or purchase agreement. It's just like when you've sued for a breach of contract and it says pursuant to the terms of the contract. Well, you have to show the contract that you're accusing my client of breaching, and they are relying on something that they have to put forward. So that'll settle your case, but I digress. The third part is our discovery request to produce the information and the basis of why they filed an affidavit. 2 reasons in their lawsuit. 2 reasons why. I jumped ahead. There are 2 reasons why, generally, why a debt collector or even a creditor attaches affidavits. Bank of America, American Express will attach affidavits. There's an insecurity there. One reason is, here we've got the stuff, but we're kind of insecure. If you look at all my MCM, Midland Credit Management videos, put a couple up there, they all pack in an affidavit, a certificate of conformity, another affidavit from Minnesota, and that is a tag or a tell in the poker world that they are insecure about what they're presenting you. So if an affidavit is attached to your lawsuit, the other reason is stuff is missing. So in a lot of debt buyer cases, an affidavit is attached to make it an account stated case. Most debt collection cases are breach of contract, and if there's no contract or it's a debt buyer case, account stated, and unjust enrichment, which is just a throwaway. But there are statutes in your state, perhaps, certainly in the ones I practice in, called account stated statutes, that require, if there's a missing contract, the debt collector to attach an affidavit. And then if you want to beat that, the statute, especially in Michigan, says you better have a counter affidavit. Are you familiar with counter affidavit with me? So that's that. So today we're going to attack their affidavit the same way we looked at the assignments and the bill of sale / real goldmine forward flow agreement. Let me put those 2 videos up there, and they're going to be part 1 and part 2. It doesn't say that on the videos, just put them up there. But this is part 3, that's 1 and 2. In my silly head, that's how I framed it. I should have put it in the thumbnail. But frankly, things get noticed, and I want you to notice these videos. We put some really sensational things in there. So I put dirty secrets, and they are. This is stuff that the industry doesn't want you to know, at least the last 2. What I'm about to tell you today, let's swish those away, is not a dirty secret. I may put it in the thumbnail so more people watch it. It's my dirty secret. This is how I go after them with the affidavit. And remember, the more they present to us, the better it is for us, because it's more to attack and show the if you want to look at in the form of reasonable doubt, they give you more stuff where the judge can go, there's something going on here. So what we do with that information is how we win the case. And as always, we build our counter affidavit that's going to be supplied with our answer that goes against them. And the counter affidavit is the building block of not just your defense, but if you have a motion filed against you, or you need to file a motion, or you need to explain something to the court, or a trial brief. If you go to trial, it is your blueprint the whole way through. Just do a little bit of work, and some of that work comes from your examination of the affidavit. So attached to this video will be request to produce forms asking about the other side's affidavit, show notes, these, an FDF, what's wrong with me today? PDF cheat sheet to create your own counter affidavit. So the counter affidavit is your examination of the bill of sale, your examination of the assignments, your examination of the complaint, and their evidence or affidavit, and you put it in your counter affidavit and say, that stinks. So you're in 2 or 3 pages showing a court exactly why they got nothing. They got nothing. So you'll have your counter affidavit attached to this. I'll also throw in a Word template answer with bad assignments mentioned. I gotta go find a couple, but we'll find them. Anyway, here are the ways quickly that we attack the affidavit. First, we challenge personal knowledge. Let me put up the video we did on evidence and hearsay. That's that. The basis of that is 803. Every state mostly has 803. So there's a hearsay. Everything is hearsay unless you can find an exception. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Bob told me Dave killed Steve. Well, whoever said and refers to Bob's stuff is making a hearsay statement unless, and it can't come in. It's out-of-court statement. Bob told me, offered to prove the truth of the matter, that Steve was killed by Dave. Well, that doesn't come in unless Bob told the declarant, the person saying this, there's an exception. For example, Bob was shot, and as he's dying, he says, Dave was shot, somebody was shot, and he says, hey, Bob killed this guy. Well, that's a dying declaration, and the courts say that's reliable, that's credible, we're going to trust him because he said that as he was dying. We don't generally lie. So that comes in that way. So 8036 is called the business records exception. Every state has evidence rules, and 6 is the business record exception. So what they'll do, collectors, to create an affidavit, they'll throw in words from the business records exception to make it sound like they have the business records exception, and this document is an exception to hearsay, which it always is. So first, let me put that up there. You challenge personal knowledge, and you are claiming that they don't have personal knowledge, and a lot of times they won't. They've got to use the word personal knowledge in their affidavit. Also, you can object to hearsay or improper foundation. Let's put that up there. And you will just say, this is hearsay, and it doesn't come in. It hasn't met the 8036 qualifications to come in as a hearsay exception. So if you have an affidavit, the fluky, no, it doesn't make sense assignments. For example, a lot of affidavits say, our predecessor in interest assigned this debt to us. No. Who? And how many people were there? And when did they do that? But it's their way of creating an affidavit. Understand this premise. I'm going to say this, and in my experience, my opinion, this is true. It's all bullshit, meaning all their stuff. There's a great line in My Cousin Vinny, and the other side, the prosecutor, just goes on this rampage attacking Joe Pesci's client. And so Now Joe Pesci's got to stand up and word for word, point for point, attack what they just said, or the judge who's ruling on the case is gonna, Pesci's client's gonna lose. So Pesci stands up and says, looks over and he goes, "What the other side said is all bullshit," instead of attacking it point for point. And I've never forgot that. Well, that's what most debt collector lawsuits are. They know their stuff is all bullshit, and now they have to, with pretzel litigation and pretzel affidavits, fill in the blanks that they can't, but they use the documents that probably fill in the blanks with BS stuff inside them, and hopefully you don't notice, but you're a disciple of me, and you will after this today, and you will not show up, which you will show up. They love the defaults. A collector's main number one desire in life, its mission statement, is to have the person on the other side not show up and default. As I've said before, 90% of collection cases are defaulted because the other side just doesn't show up. So you will look at their assignment proof. If it isn't there, that's part of your counter affidavit. Examine the notary. This is a fun one. Let's put that up. Examine the notary and execution issues. You're going to see today an affidavit where they made all these allegations why they own the debt and didn't notarize it. And there's a reason, and didn't date it. And they called it a business affidavit. Again, what are they using the word business for? Because they want to fit in the under the business records exception. So inconsistent and contradictory information, that is just you looking at the complaint, and this happens all the time, and then their affidavit of proof, they'll in their complaint, they'll go, see bill of sale or see affidavit. So you do, and you see it doesn't match up. That happens because they're in such a tizzy. And by the way, how an affidavit is created 99 times out of 100, a law firm creates it that they've hired to execute on this debt, sends it to the notary who signs. None of that stuff's being done that they claim to have done, my opinion, but guess what? I've deposed those people that have signed. And this last one, affiant, I deposed, I couldn't stop thinking, deer in the headlights. Every time so when you wrote this, what was going through your mind and what documents were you looking at? She just stared. And so even the other attorney's like, hello, it's a Zoom dep. She just stared. So we had to keep pushing her to answer the way that she didn't want to answer. No one had ever said, hey, did you actually do this before? Because there's such a small amount of people fighting these things. They don't have to lift the heavy weights that you and I have to lift. They're all lightweights. So I'm a mean guy coming in, but I'm not. I'm just asking for the truth. They never collectively get this stuff together. Or like in Midland Credit Management out of Minnesota, every case you get, there will be a Minnesota affidavit. I've deposed those affiants too. And how do I put this? It's very interesting. It's like they have different states put together a piece of the puzzle. Here's the affidavit. California puts this together. If it's in Michigan, Michigan signs off on somebody that maybe created the complaint. There's actually a violation of the FDCPA. You are in violation of the FDCPA, attorney, if you don't have meaningful involvement in the coming together of the complaint you're signing. So a lot of the times now, the complaint will be just the same cover your ass language as in affidavits. The complaint will go, I took a look at all the records and everything, and then sign, and it's electronic signature. So there's a lot of bad situations and people doing interesting things in this area of the law. Well, where money is involved, weird things happen. So you're going to also look at, as I said, discovery issues. Is it meeting the 803? Let's put up enforced discovery obligation. I'm going somewhere with this, even though it's boring. You have to look to see if it meets the 8036 exception to the hearsay rule because everything is hearsay. So debt collection lawsuits are vulnerable if not properly executed or rely on these kind of hearsay affidavits. So go after those affidavits and you'll win your case. We're going to look at some affidavits now where they are vulnerable. So this is what I'm going to do to help you. So if this other stuff, nonsense, I need you to focus on this for yourself. Let me put up this list. Shazam. Personal knowledge, hearsay, strict proof of assignment, notary execution issues, contradictory documents. Is the affidavit relying upon data not attached? So as you get your affidavit, take my list and do a check mark. I even, again, to this video, I've attached a PDF cheat sheet for you in examining their evidence and creating your counter affidavit. So let's try to do one. We're going to put up, this is I titled, "It is so bad it is funny." Winner of 2024 It's So Bad It's Funny Award. So let's put what they call an affidavit of account, Shazam. Again, why is it called affidavit of account? Because it can fit into the account stated statute of any state that they're filing a lawsuit on. They did not, in this case, have a contract. Again, the two reasons why they use affidavit: to confirm or conform to the evidence they claim to have they don't have, and because they're insecure about not having it, in case of people like me come along, or they're missing something, usually a contract between the defendant, me and you, and the original creditor. So the affidavit in some states, in most states, fits right into that and makes up for the lack of a contract. So here, we're going to keep it up, and to the side, let's put that checklist that I just showed you about, and let's go through it without having too much paper. So, is there personal knowledge? She does not say she has personal knowledge, meaning the person that signed this affidavit. So that's a check. Is there any proof of assignment? She says that in the ordinary course of business, plaintiff regularly purchases contracts from the original creditor or their assignees. That says nothing. You got to say who you're getting it from, who the original creditor is. So there's no way she's part of this process working for this company, even though she signed off on the company that I'm currently suing. Put up and this is that great, it's a great video. It really nails these guys. Put up my smelly socks video. That's right, I named it Smelly Socks. There it is. Oof, let's get rid of that. So also, contradictory other documents. It doesn't mention the assignments, and also she's claiming to look at stuff without saying personal knowledge under 8036, but she doesn't show any proof of what she's relying upon. That's important. You can go after him for that. Excuse me, it's one of the cats. Really, you want to come in? There, he's over there. He's looking for the other cat. So that's how we knock them out. Also with that, the defendant is called a defendant, and this is, depending on your state rules, your account stated statute rule, before the lawsuit's even filed. So they're not defendants until the lawsuit is filed, so that's false too. So they signed that under oath, but that's a false statement. So that's how we examine that. Let's look at another one real quick. This is a favorite of mine. This happened after after we were going through litigation, and suddenly an affidavit popped up during litigation to help them. But again, as always, it didn't, it hurt them. And here we're going to show you the way. So put up the business records affidavit. Again, they name it the business records affidavit, so it fits nicely into 8036, the business records exception. BS on that. I'm calling BS on that. So put that up. And if you look at, we'll put up our list to the side or somewhere if you can. Let's see with the list what's wrong with this. So we check mark hearsay or improper foundation. It's an out-of-court statement offered to prove the truth of the matter asserted. None of what is said in the affidavit is backed up. I'm going to show you why. We're going to X mark strict proof of assignment. Doesn't have it. It says it has all these documents, but there's no reliance on them, and I'll show you why again. Now here's my favorite. This is called my favorite affidavit. Are you kidding me? Affidavit. Winner of the Are You Kidding Me 2024 Award of Bad Affidavits. Look at this. This says clear notary executions issues. Why? Is there something wrong with the lady that notarized this? Was it not sworn under oath? There is no notary. How can this be an affidavit when most court state rules are you have to be sworn under oath? If you look at the bottom, further affiant saith not. That's language of every affidavit that's sworn under oath, but they just sign it and they don't even date it. I love that. I know it doesn't sound, why would you love that? Because you can poke big holes in that, right? And why would they not date it and not swear to it? Because it was done after litigation and they figured out how I was coming after them. So they wanted to pretend that this affidavit showed that Mr. Parker is wrong, but if they date it after they found out my stuff and after the lawsuit was found, that's clear hearsay done for the purposes of litigation rather than credible, reasonable reasons for doing that. And so if you undate it, you can't be accused of doing it during litigation. They think the judge is just going to go, whoa, I guess it happened before. When they do stuff like that, I go, are you kidding me? It's so wrong. No affidavit, no date, no notary. And we're supposed to pretend that that happened before the litigation, whatever. But is the affidavit, check mark, is the affidavit relying upon data not attached? So it says in a couple places that attached hereto are 307 pages of business records. And then the next paragraph, that there are 307 pages of records kept by Upstart with no records attached. So during a hearing, I said, well, where's the 307? Because there's no proof so far. And they go, trust us, Your Honor, it's in there. We didn't want to burden the court with 307. She goes, okay. No, it was a judge out of the 48th District Court. It's like, okay, that's all right. And dismissed against me, just killed my case. And I'm like, wait a minute, if they're going to rely upon it, you got to show you. And this is how they get mad, the judges get mad. Your Honor, what number of the 307 pages did you review? He ain't reviewing anything. He's got too much to do. So now they get mad. Mr. Parker, if you don't like the decision, you can appeal it. And I'm like, I just want you to rule based on the work that you're supposed to have done. And I don't pull my punches. I really respect the court and the judge. But if they make decisions not on the evidence, or if I do all this work and they don't even read it, and you can tell, then sorry, you're not being judged like, you're just being a regular person, so I'm going to treat you as such, with deference and respect, but you ask in a way that they know what you're really saying. And then when they get mad, that confirms they know that they didn't, and you know they didn't, yada yada. So that one's in appeal. So here's another last one from Velocity. Shazam, it just says affidavit. Okay, it names my client as a defendant, again, before the lawsuit's even filed. Remember, these things are mass produced before a lawsuit is even filed or done by somebody else for the attorney to sign. And I've deposed, if you looked at my my deposition of a debt collector attorney, remember Mr. Johnson? Let's just put number 1 up there. Go look at number 1. Just the first 10 minutes, you'll be hooked. It's must-see TV. But in that video, he said, look, this job's really easy. They just give me forms and I sign. I don't have to do any work on these things. So who's creating the complaint if he just signs? And then he looked at me and said, you screwed this all up with all your defenses. So he got really mad. So it's just forms for them. Sign, sign, sign. It's an easy job, right, as an attorney. So unless you're facing this crazy person. So also they refer to the client as defendant, defendant, defendant again, and themselves as a plaintiff. There is no plaintiff or defendant that you're swearing under oath there exists until a lawsuit is filed. They refer to number 3, plaintiff's predecessor in interest sold and assigned all right, title, and interest to in the defendant's, client's not a defendant, Cross River bank account to the plaintiff. Plaintiff doesn't exist at this point. It's just forms that fits nicely into their modus operandi, their way of doing business. And then you or I come along and go, hey, wait a minute. The emperor's not wearing any clothes. So again, let's just put up the list. Boom, personal knowledge under 8036. No personal knowledge mentioned in the last one. Oh, I did some digging. The affiant put their address up there. So I went and checked it out. It doesn't even belong to the company that's presenting this as evidence. Velocity Investments. The name of the company that she works for is CKS Prime Investments LLC, owned by Velocity Portfolio Group Inc., a separate entity. So I deposed her, and she admitted. I said, who signed your paycheck? Velocity Portfolio Group. I said, you don't even work for this company. You just said you work for the company. Deer in the headlights. So another one, strict proof of assignment. Boom, check mark. No reference to other signers, just predecessor and interest. That's not a company. And you need specificity and not confusion, as I said in my assignment video, the last one, part 2. Contradictory other documents. The complaint in this case actually contradicted the information in the affidavit. There was clearly a trust, and they admitted, it's right in the bill of sale, there was a trust. They didn't include it in the affidavit. So in their bill of sale, they say there's a trust that gave us, Velocity, the debt. You go to the affidavit, and there's nothing about the trust in there, and that happened. So you recall my last video, I talked about how I was facing a motion for to compel arbitration. And at the last minute, out of the blue, came an affidavit that said, for the first time in all the time I've been doing Velocity cases, every single case I have, a trust gives it to Velocity. And then several days later, the original creditor, usually Cross River Bank or Finwise, sometimes Blue Ridge Bank, will then give it to Upstart. After somehow Velocity got it from this weird sounding trust. So that's contradictory. Cross River would have to give it to somebody else, or the trust to give it to Velocity for Velocity to sue. And it's that obvious. You wouldn't believe how hard it is to go to a judge. Judge, it should go like this, like this, like this. They're going like this, then like this with no proof. And now I'm down to Mickey Mouse emojis, I swear. I now give the court an emoji of Velocity receiving something from this company, and then an arrow from nobody, from dead air. And courts are like, well, it says right here Velocity owns it. I said, hello? You have to break it down because they don't want to pay attention, because you don't want to clog your courts. Their courts up with facts and laws and defenses. It's sad. So in that case, for the first time ever, Upstart Velocity presented the missing link. On all of these Velocity cases, nobody's ever presented an affidavit or an assignment or a bill of sale showing how the weird sounding trust that in every case gives it to Velocity to have standing to sue to my client. So I always say, hey, where's the missing link? They presented it in litigation after the case was filed, so it's, hearsay weird at that point. So it says, refer to this bill of sale, and I showed you the bill of sale, but it was undated and not signed by anybody. Give me a break. And Michigan's quite clear, most states are, for a bill of sale to be true or an assignment, you must have at least one signer, and it must be dated, right? So I filed a motion response saying, essentially, and I in my motion, if you look at the assignment video, let's put it up quickly there, the assignment video, attached to it, you'll see my motion brief, and I go, essentially, are you kidding me? I write, I'm not going to answer anything else they said in the motion. Let's just get to the root of the act. The affidavit. It refers to a bill of sale. It's unsigned, And this is what I told you guys to do. Find the statute or the rule or the case law that says how an assignment is created. You may do that and do that. How is an affidavit created to be proper in this case when you're looking at affidavits? Anyway, so the rule in Michigan is it's got to be signed by an authorized party. There were no signatures, and it's void. Again, void means out. Voidable means and usually if something's voidable, the court finds a way to let it in. But the statute was hard-nosed. It says it's void if it's not signed. So that's how I present it to the court. I send it to the 4 attorneys. I always have to face like more than one attorney. Why do they need 4 attorneys? So I sent to the 4 attorneys. I get this thing back. You know what? We really need to settle this. That's what happened. So my client was very happy. We haven't signed a release, so I can tell you that. So that's what you got to do. You got to go deep. You got to do a deep dive. It's kind of fun. For me, it's fun. I love catching liars. I love catching liars. And the thing is, they know it's fiction. That's what bothers me the most. I know that they know that I know that it's fiction. That's a hearsay examination. It's fiction. They know it. It's pretzel litigation. They try to make it so that everything matches up. It never does. Like I said, that Court of Appeals case, that's some of the biggest fiction where at the Court of Appeals, they go, where's the missing link? There's 2 of them. She goes, trust me, they're in these documents. It's the custom of the trade. There's so much documents, I don't want to get into it. You're not doing that at the Court of Appeals. But they get away with it at the lower levels because they're busy, I guess. They get paid $170,000, the judges, or something very nice. They do your job. It's our taxpayers just asking you to do your job. So anyway, I digress again, it's my opinion. Attached to this video will be a request to produce forms. It's a request to produce document that you can go ask about the affidavit. The show notes. This will help you actually. The PDF cheat sheet to create your own counter affidavit. I'm not giving you work to do, but it helps you examine their documents so that you can put your counter affidavit together. Your counter affidavit, I'll give you a counter affidavit citing the elements of the bad affidavit. You need that to attack their case and present your defense. It's a good thing. And then I'll throw in an answer with bad assignments mentioned for you, word template as I always do. Killdebt.com, we have over 1,000 documents. We have 288 videos, all there, and it's just one price a month. I'm going to announce this now. This is work, man. This is by popular demand. We're going to create what we call a form vault on killdebt.com. All the forms. So you're like, I don't want to have to look at his face in a video. I just need the forms. We'll just have a vault form that says, hey, here's all the forms for Bank of America, credit collection, all the debt buyers, how to do an affidavit. Here's our free stuff. Here's a form on Discover Bank, all the forms, all the answers, all the counter affidavit. Here's a counter affidavit. Here's how to criticize an affidavit. Here's how to show up in court. All the forms to fight an MCM case, a UHG case, all the answers, the counter affidavits, motions, discovery, all the forms will be in the forms vault by popular demand. People said, why do we have to look at him all the time and his nonsense? No, they didn't. But they said, I just got a lot of feedback where like, where are the forms? So we're going to have a forms vault or forms bank on killdebt.com. Give me some time. I'm writing it. So what you will see, the evolution of it. We'll add some companies just so we can get some up, and then we'll just keep adding to it weekly. There's over 1,000 of them. So don't yell at me if the company that's suing you in your debt collection case is not currently up there. Remember, we got 288 videos with all those thousands of forms and a video instruction and everything else. We're just trying to laser beeline this for you. So I hope this video, it was a lot of lengthy video today. I hope it goes well. Hang in there with this video. Thank you for hanging in there if you got to this. Like, love, and subscribe. Go to killdebt.com. It's just one low price for 1,000 forms and 288 videos. It's just fantastic. It's just a real good price and a good deal. I hope you think so. All right, if you are, thanks for being a member. If you're a watcher of this YouTube, give us a comment. Let me know what I can do more for you or a video you need. I hope this was helpful today. This is the third part of a 3-part series on taking out their paperwork. Thank you very much. Have a great day.